Minister, I am delighted on behalf of Fianna Fáil to move what is a very important piece of legislation, the Family Home Mortgage Settlement Arrangement Bill 2014. Which was formally moved back in December, and I'm glad now that we have secured some private members' time in the House to have a proper debate on this bill. Minister, this bill is all about the family home, and the family home in Ireland, for very many families, is under serious attack. The truth is at present that hundreds of applications for repossession of family homes are being placed before circuit courts right throughout this country every single week. There were over 8,000 such applications last year, and very many families tonight, Minister, are staring in the face the grim but real prospect of losing the roof over their head. And I believe that we are duty-bound in this House to come up with solutions to that crisis. We have identified one specific issue in terms of the operation of the Insolvency Service, which, if addressed, we believe would go some way at least to addressing this crisis. The reality is, Minister, that the Insolvency Service is not working when it comes to mortgage debt. In fact, it is failing abysmally. And if you look at the facts, that less than 200 personal insolvency arrangements have been approved up to the end of December, in the context of 118,000 family home mortgages in arrears, then you really get the sense that it is a drop in the ocean. And one of the reasons why the Insolvency Service is not working is, of course, because of the power of veto which the government has given to the banks. And that veto is at the heart of the legislation that we are putting forward in the House here tonight. And we are seeking to bring about a redistribution of balance in terms of the power which has been given to the banks and at the expense of the borrower. Ciara, you might tell me when there is maybe 5 minutes left, because the clock there isn't counting down. Ciara, I welcome the opportunity to move to second stage of the Family Home Mortgage Settlement Arrangement Bill 2014 on behalf of Fianna Fáil. We do so at a time when the scale of the mortgage arrears crisis for Irish homeowners is indeed unprecedented. The essence of the bill that we are moving here tonight is to remove the veto that banks currently possess in relation to restructuring arrangements under the Insolvency Service where a family home mortgage is involved. It is our belief that unless decisive action is taken, we are facing an unprecedented wave of repossessions in 2015. And that is being evidenced and borne out by the reality which is happening in circuit courts right throughout the country with each passing week at this stage. Widespread family home repossession is not a phenomenon that Ireland has experienced since independence, thankfully. However, we do know that it will lead to significant social upheaval. In fact, this is already beginning to be the case. We only need to look at the impact of the laissez-faire approach to mortgage difficulty in the UK in the 1990s to see the truly devastating social consequences of potentially thousands of families losing their home. As it stands, in the absence of a significant legislative initiative, the 37,484 people in arrears for more than 2 years are at a very high risk of losing their homes. And that is the reality, Minister. That is why we are appealing to the government to accept the legislation we are bringing forward today, to give families a fair chance to put in place a restructuring arrangement that will allow them to stay in their home. And we do this in the genuine belief that in the vast majority of cases where mortgages are in arrears, if the will is there on all sides, then a sustainable solution can be identified and put in place. At the outset, I would like to deal with a couple of points made by the Taoiseach when the issue was raised by the leader of our party, Deputy Micheál Martin, in the Dáil this afternoon. Firstly, the Taoiseach stated the solution that has been put forward by Deputy Martin's party is not a solution because it is referring all of these cases to a court of law. Well, I have to say that it is disappointing, to say the least, that the Taoiseach will engage in such a blatant diversionary tactic. The fact of the matter is that these cases are already coming before the Circuit Court. Under the current insolvency regime, all arrangements put forward by the Insolvency Service of Ireland must be approved by the court. And the Taoiseach, if he doesn't know that, should know that, and it really beggars belief as to why he threw in that red herring today. We have replicated this model, but minus the veto which the government gave to the banks. In addition, under current legislation, repossession proceedings must be commenced by means of a civil bill. In 2014, a total of 8,164 civil bills for an order of possession were lodged in the Circuit Court. Our bill would avoid the need for an adversarial court setting and adapt the structure provided for in the Insolvency Service of Ireland to deal specifically with the question of distressed family home mortgages. And I stress again, we are talking here about family home mortgages, not buy-to-let or investment properties. The Taoiseach also stated today, Fianna Fáil's intention, in my view, is to impose a solution from its perspective that actually is unconstitutional. Well, it would be useful to know if the Taoiseach sought the legal advice of the Attorney-General, who is, of course, the Government's legal advisor in these matters and guardian of the Constitution. And I expect, Minister, that you will confirm whether or not this is the case. I can only assume that the basis on which the Taoiseach is claiming the bill to be unconstitutional is Article 43, provision protecting property rights. Based on the legal advice we have received, I do not believe this to be the case, as there are already legal provisions which limit property rights, including the established mortgage arrears resolution process. In fact, if property rights are as sacrosanct as the Taoiseach seems to believe, then his colleague, the Minister for the Environment, Deputy Alan Kelly, will not be in a position to introduce his proposed rent controls. What we are seeking to do with this bill is to introduce a bold initiative aimed at going a long way to resolve a major social and economic crisis. If the banks have a problem with it, then quite frankly they are entitled to challenge it in the courts. It is my belief that the premise of the bill is constitutionally sound. I would like to outline some of the reasons why this legislation is necessary. There is now a clear strategy on the part of the banks to step up legal action for repossession of family homes in cases where people have fallen into arrears on their mortgage. The banks have decisively ramped up repossession actions in recent times. The rapid rise in house prices in 2014, particularly in the Dublin region, has given them the opportunity to substantially reduce the losses they would face from selling a home in mortgage arrears. Having kicked the can down the road for a number of years, the banks are now emboldened by the complete lack of legislative protection and by an acquiescent government that wants to sell the state's holding in the banks at the first opportunity. Banks are using a variety of tactics, including direct court action, as well as selling off parts of their loan book, a method that essentially amounts to outsourcing of repossession. More than 15% of family home mortgage accounts are now in arrears, amounting for over 20% of the outstanding value of all family home mortgages. Mortgage arrears for family homes are now in excess of €2.5 billion, more than 3 times higher than the figure at the end of December 2010. The most recent stats from the Central Bank show that a staggering 118,000 family home mortgage accounts are in arrears, and almost half of those are in arrears of 1 year or more. Since December 2010, the number of those accounts in arrears of more than 180 days has more than doubled, from 31,000 cases to 74,000 cases in less than 4 years, with those 74,000 cases having combined arrears of €2.4 billion. The mortgage arrears crisis is now so ingrained that over 30% of accounts in arrears are more than 720 days in arrears. That is €8 billion worth of mortgages. Repossession of a family home is a grim possibility for tens of thousands of families. At the last count, almost 1,400 residential properties were in possession by the banks, well more than double the figure at the end of 2010. But that is, of course, just the beginning, as an avalanche of repossessions is in train, as a consequence of the coming into effect of the Land and Conveyancing Law Reform Act 2013. As I highlighted to the House on the 4th of November last, the numbers involved are simply frightening. By way of example, in the first 6 months of 2013, there were only 44 ejectment civil bills in Cork Circuit Court. In the second half of 2013, this increased. There were 246, and this grew to 335 for the first 6 months of 2014. We are now at a situation in Cork alone where we're looking at least 100 cases per week being brought before the courts. Such is the increase in activity by the banks in terms of enforcement action that additional court sittings have had to be organised, and that situation is repeated right around the country. Even more worryingly, figures released by the Minister for Finance in November last show that for every home actually repossessed by court order, another 3 are voluntarily surrendered or abandoned by the owner, under pressure from the banks. At the moment, there are really only 2 options available to a family struggling to meet their mortgage repayments, but who wish to stay in their home. The first is to reach an agreement with their lender to restructure their mortgage. The second is to enter into a personal insolvency arrangement under the Insolvency Act. In both cases, however, the bank has a veto and can refuse to accept the homeowner's proposal. The bank can threaten repossession as a means to force a borrower to accept a restructuring that is not suitable for them, because there is no other realistic option available to the homeowner in which the bank does not have a veto. If a borrower does not accept the bank's wishes or cannot comply with the level of repayment their bank demands, they face the possibility of both eviction from their family home, but also a lifetime of debt if their home is sold for less than the outstanding amount of the mortgage. The power imbalance that now exists between mortgage lender and homeowner is truly extraordinary, and that is as a direct result of the government's policies. Deeply unfair and completely out of place in a modern democracy. The bank holds all the cards as a consequence of their inbuilt vetoes, and because the consequences for a homeowner are so significant that they cannot reach an agreement with their lender. The legislation we introduced today would transform the relationship between homeowner and the bank, as it would remove a lender's right to an unqualified veto over reasonable solutions proposed on behalf of homeowners who have fallen into arrears on their mortgage for their family home. Restructuring of mortgage accounts by financial institutions has increased, yes, but so too many homeowners are falling through the cracks. The government's solution for those who have not been able to restructure their mortgage with their lender, or who have unsecured debts alongside their mortgage arrears, is the personal insolvency arrangement, or the PIA. But only tiny numbers have availed of this option so far. At a time when well in excess of 100,000 family home mortgages are in arrears, only a mere 218 people with secured debts were granted protective certificates in the last quarter of last year, the first step towards a possible PIA. An even smaller number had a PIA actually approved by their creditors. A mere 119 such arrangements were approved in that quarter. Almost 30% did not have a successful outcome. In fact, less than 200 PIAs have been approved by the Insolvency Service since this option became available in 2013. So it's based on 16 months of hard data. 199 PIAs involving secured debt actually approved by the Insolvency Service. 199 in the context of 118,000 family home mortgages in arrears. I mean, by any measure, Minister, it is not working, and we have to acknowledge it's not working and face up to the underlying reasons why it's not working in terms of dealing with mortgage debt. Such low numbers of successful arrangements show the extent of power of veto given to secured creditors in the government's personal insolvency legislation. In fact, there were more bankruptcies in Q4 of 2014, 147, than there were successful PIAs. To put it into perspective, there were far more applications for repossession in Cork Circuit Court alone in 2014 than there were successful PIAs nationwide. People are being forced into bankruptcy. I mean, is the government's solution for people in mortgage arrears to end up in bankruptcy? Because that's really the coded message that the government is sending. And the banks know it. They have the option of bankruptcy with a 3-year discharge period and another number of years hanging over their head. People in mortgage arrears should not have to become bankrupt to have their mortgage problem dealt with. That's the overriding message, Minister. Bankruptcy is there for people who have more complicated debt arrangements, including business debts and other related debts. Those who have been able to persuade their secured creditors to approve their PIA proposal have been forced to accept surprisingly small write-offs of secured debts to ensure that their proposal is approved by their creditors, with the average write-off of secured debt being only 16%. In some cases, there has even been no write-off of secured debt at all, with the PIA used to reduce unsecured debt only. The extent of the failure of the PIA route to deal with family home mortgage arrears can be seen in the fact that less than 40% of the debt in cases currently with the service relates to family mortgage debt. It is our firm belief that banks should not be able to act as judge and jury when dealing with homeowners who seek to restructure their mortgage to avoid repossession of the family home. Where a sustainable solution cannot be agreed between a lender and borrower in respect of a family home, the matter should be dealt with by an independent party who can hear from both sides equally and mandate a fair solution that is beneficial to both parties, not just the bank. And that is the essence of what we're proposing. This bill provides that a homeowner who satisfies the eligibility criteria set out in the bill may propose a family home mortgage settlement arrangement to their lender in relation to their mortgage. To be eligible to make such a proposal, they must have engaged in a mortgage arrears resolution process under the Central Bank's Code of Conduct on Mortgage Arrears and indeed exhausted the appeals process that is set out in the Code. A proposal could only be made by a licensed insolvency practitioner or PIP who would assist a homeowner in completing the prescribed standard financial statement and ensure that it is accurate. A proposal for a family home mortgage settlement arrangement would only be possible where the PIP believes that there is a reasonable prospect that an arrangement would facilitate the homeowner paying off the arrears on their mortgage, but that there would be no prospect of them being solvent within 5 years without such an arrangement. After a thorough review of the homeowner's financial circumstances, the Insolvency Service would issue the necessary certificate to the Circuit Court, which could in turn issue a protective certificate. For a period of 180 days, the borrower would be protected by the protective certificate from the lender commencing or progressing any legal proceedings or taking any step to repossess their home. During that time, the PIP would prepare a proposal for a family home mortgage settlement arrangement, which could include any of a range of 14 options set out in the bill, including paying interest only for a period, permanently or temporarily reducing the interest rate, extending the term of the mortgage, changing the type of the mortgage, having a split mortgage, reducing the principal sum, etc., etc. They're all laid out in the bill. The Circuit Court would consider the proposal and all associated documentation at a private hearing on which both sides could be heard. The bill contains a number of important safeguards too, Minister, to avoid the legislation being misused. A homeowner may only enter a family home mortgage settlement arrangement once, and while an arrangement is underway, the lender could apply to the court to terminate the arrangement in limited circumstances, for instance if the borrower has failed to comply with their obligations under the arrangement or has fallen into arrears of 12 months in respect of payments under the arrangement. The court would have the option of terminating or varying the arrangement in those circumstances. In conclusion, tens of thousands of families are currently left in a position, Cahirlock, where they must comply with the demands of their bank or face eviction from their family homes, and potentially the crippling debt of a significant shortfall when their home is sold for less than the amount of their mortgage. The solutions currently available are totally bank-focused, giving a lender a complete veto over any proposal made by a homeowner. This legislation, if enacted, would rebalance the relationship between the bank and the homeowner by allowing the Circuit Court, on the recommendation of the Insolvency Service, to put in place a fair, equitable and sustainable solution that allows a family to remain in their family home while paying a sustainable monthly mortgage payment. If our proposals are adopted, there would be a considerable improvement, I have no doubt, in the current situation, with a much higher proportion of successful restructuring arrangements being implemented. It would put the interests of the mortgage holder at the centre of the process and act to dilute the control that the banks currently have over the process. Minister, I honestly believe that if the government is genuine in its efforts to deal with this ever-growing crisis, then you would accept this bill. Imperfect and all as it may be, you would accept the broad principle of this bill to remove the bank veto that currently operates in the Insolvency Service when it comes to family home mortgages. And you would allow this bill to be teased out in much greater detail at committee and report stage, because there is a fundamental flaw in the Insolvency Service as it is presently constituted. It's not working. We have to accept that, Minister. This was the overarching state response to the mortgage crisis, the setting up of an independent statutory insolvency service. And it's not functioning because it has both of its hands tied behind its back. Because at the end of the day, the government allows the banks to call all the shots. Not only do you allow the bank to propose so-called solutions under the Mortgage Arrears Targets programme being dressed up as threatening legal letters, and the bank saying, well, we've fulfilled our responsibility, we've offered a so-called sustainable solution, a threatening legal letter, but you're now allowing the banks to veto. And Bank of Ireland and Ulster Bank have come before the Joint Oireachtas Committee on Finance, and a number of members here were present at those hearings, where they publicly stated that they would veto any proposal put before the Insolvency Service which involved a write-down of mortgage debt. That is not acceptable, Minister. It's not acceptable. And if you had any sense, you would at least allow this bill to pass second stage and let the threat be hanging over the banks that if they don't cop on and if they don't stop thwarting the work of the Insolvency Service, then you will enact this legislation and dilute that power fundamentally.